Hello, I'm Robert. I'm helping you if you're scared of many things. And this time it's about people who may be who are LGBT in the United States and to worry about the effect on them of the Supreme Court overturning Roe versus Wade, the uh, the Supreme Court about abortion. So first of all, we don't know if the Supreme Court's going to turn it over. It's going to overturn it. But also, Alito's draft says very clearly that their conclusion does not undermine the right to gay marriage, to contraception, and so on. And uh, first of all, this is to help scared people, and it's not an argument in the pro-choice or pro-life debate. So I'm not doing it for that reason. I'm from the United Kingdom, where it was settled long ago, we're pro-choice in the United Kingdom, and so nobody here even discusses our law. And the legislators likely don't yet know what their final decision is going to be. But so what I'm looking at is whether there's any implication if they did decide. So I've talked in the previous video about the effect of their decision on uh, what the United States people can do about choice, the ones who are pro-choice, what they can do about it, in the previous video. And it's basically if they did make this decision, which is not at all certain, then the solution is to use the legislature. So they then have to vote in people, and then there's a legislative path that can lead eventually via a carve-out of the what you call a carve-out of the filibuster. It can lead to the a possible legislative Roe versus Wade. So that could still happen. So we've got the possibility in the future that the Roe versus Wade is not overturned anyway. So that's definitely still possible. And if it is overturned, then there's a path which actually is more feasible than people realise to an actual legislation of Roe versus Wade after the midterms, if the Democrats have a good midterms. But now, this is about so first of all, this has no relevance to LGBT, because on the only big case so far, the court has actually retained a 6-3 split, which is pretty much how they were before the new Trump appointees. And the reason is that these are justices. They make their decisions by legislative philosophies. They don't make their decisions according to personal views. So they're not Republicans, they not belong to any political party in their justice decisions. They could be a Republican or a Democrat. You could have a Democrat who is historist, who makes decisions that the Republican president likes. They wouldn't normally disclose whether they vote Republican or Democrat. And for all we know, it could be that some of the Conservatives vote Democrat, some of the Conservative justices. So it's not anything to do with whatever their party political votes might be. And the presidents just select. It looks through all the justices. This justice chose that. Oh, he did a pro-choice decision there. Well, that justice didn't make a pro-choice. That one did. That one didn't. And then, well, we'll go for that one. Now, which of all the justices that did a pro-choice case, which did the most pro-choice decision in their decisions? Okay, we'll go for that one. That's basically how the precedents go. And this doesn't tell them anything about how those justices decide in LGBT cases, because they're based on very different legal precedents. So there's absolutely nothing that in this to suggest that even if they did decide, because they have been chosen to be pro-choice, pro-life, they've been chosen not to be pro-life in ideology, but be pro-life in their judicial decisions. So that's no surprise if they turn out to be quite a bit pro-life in their final decision. And it's not their fault, because they are making legislative decisions according to their best approach. They're not being biased. It's just that the president selected justices that happen to make the same decisions on Roe versus Wade. They're not ganging up in any way. It's just that that's the sort of decisions they make. And so it's no surprise that since justices were chosen and made those decisions, then that's not surprise that they make a decision that either reduces the time period to 15 weeks or maybe it eliminates Roe versus Wade, which is a great surprise, but it might happen. So there's no effect on the judicial decisions about choosing Roe versus Wade because it's independent. So the only question really is, could their decision about Roe versus Wade have an implication on future decisions about gay marriage, say? Could it be that in a deliberations in a future case about gay marriage, that they refer back to this Roe versus Wade case and say, well, back then the Supreme Court decides such and such, so therefore that's a precedent, so therefore we've got to do the same now. So that is what the whole question is about here. And the answer is no, it would not. So this is Alito making it, and he does that. He said they do not support. So the cases they looked at, the Supreme Court cases on things like contraception, like the gay marriage, and various other things they looked at. He said about them, they do not support the right to obtain an abortion, and by the same token, our conclusion that the Constitution does not confer such a right does not undermine them in any way. So, in other words, he's saying that they're different from abortion rights, and that if they make a decision that the Constitution does not confer a right to abortion, and then this means nothing either way about the right to gay marriage. He says that as a legal opinion in his draft. He's talking about legislative, whether the Supreme Courts are tying their hands. And the justices, some of the justices, especially the ones in the middle, then are not very keen at making a decision that could tie their hands on other issues in the future. And that can be an actual consideration and say, well, we should make a tighter decision. We should make a narrower decision. So that could be a reason for choosing 15 weeks rather than eliminating Roe versus Wade if they thought they would tie their hands for future decisions. Because that's another thing. They don't want to make overbroad decisions. They normally make as narrow a decision as they can. And a decision that impacts on future future Supreme Court decisions could be seen as being overbroad. And then the reason that the reasoning for why it's different is that abortion destroys what these decisions call potential life. And so really he's saying that if they do make this decision, and it's a very early first stage draft, they may not. If they make this decision, it only impacts on other decisions that involve potential life. And obviously gay marriage and contraception, contraception destroying potential life. So it's not preventing potential life, but destroying it. In this case, the life of an unborn human being. And so they're saying that's potentially different. And none of the other cases, cited by Roe and Casey, involve that. And so they're therefore in opposite. So that's why they said that's their reasoning. Whether they eventually come to that reasoning, we don't know. But that's their reasoning in this draft. And so if that reasoning is there still in the draft, then he is saying that it would not impact on gay marriage. And so this is in context. So he gives a whole list of all these things, like Casey, which is the second case to do with abortion after Roe versus Wade, which is the first one. Then the right to marry while you're in prison, the right to obtain contraceptives, the right not to be sterilized without consent, the right to make decisions about the education of one's children, So these are all things that Casey saw as being related, they don't see as being related. Right to engage in private consensual sexual acts, and the right to marry a person of the same sex. And they don't say that abortion has a sound basis in any of these. So they're using different principles from Casey, which did see a precedent in these cases. So Casey said there's a precedent in all those things, and they're saying in this draft opinion only that there is no precedent. And it's saying that these attempts to appeal to a broader right to autonomy prove too much. So he's claiming that he claims that these criteria could also license fundamental rights to illicit drug use and prostitution. So he's using that as an argument. So therefore, we shouldn't use that approach, because if we use that approach, we'd also license illicit drug use and prostitution. So that's his argument. Whether the other justices agree with it or other people do, but that's what he's saying. And then he goes on to say that abortion destroys what they call potential life, and it's life as an unborn human being. And I just read that bit out. So that's why he's saying they're different. And so that's why he's saying it's got no relevance to gay marriage. So legally precise, it won't legally tie their hands for any future cases on those things. And as I said, the draft trial balloons, we don't know how it's going to go. Now, people say, but what about the long historical section, which looks at even medieval legal opinion? It went right back to the 13th century. And people claim that this long historical section is an attempt to ground present-day law in 17th century and even medieval legal opinion, but that's not what he's doing. If you look at that entire section, it's rather the other way around. He was looking for historical cases where abortion was not criminal. So that was what he was searching for. He says that at the beginning of that section and then at the end of it. But if you read the middle of the section and you don't read the start and end of it, or you don't see how it fits in context, you could think that he was trying to use that to argue abortion. But it's very clear the way it's framed that he's not doing it like that. So he found no historical cases where abortion was not criminal. He found no legally convincing cases. They might look at just before Roe versus Wade, where he found some cases where he found that some states had just started to make it legal, but 30 states it was still totally illegal. Then went back to ancient history and he looked at all these other cases, and it was, and he found no cases where it was legal. So now that might change. Maybe another justice will find an ancient case from the 13th century or the 17th century or something where abortion was legal. But so far he's found no historical cases where it was legal. So then he went on to say, therefore, the historical argument doesn't apply. The inescapable conclusion is that the right to abortion is not deeply rooted in nature's history and traditions. That's what he said. So I'm taking a little bit out of there. And so the one source that were found that said abortion wasn't criminal was by a pro-abortion advocate, and its articles have been discredited. So he's saying it's not deeply rooted in historical conditions. So he went on to say that even Casey didn't seriously press the historical argument. He went on to say that it's instead of being a historical argument, that Casey went on to say it's a broader, entrenched right, as the freedom to make intimate and personal choices that are central to personal dignity and autonomy. So then he goes on to look at that approach, and this is an entrenched right, to have a right to abortion, and then so that ends a long discussion. I haven't actually read that in any detail, but that's basically went on. Then they went on to reliance after that, and whether the historical public have trained on reliance. And obviously at the end of this he comes to the conclusion that this isn't a judicial, so it isn't as the judiciary, in this draft only, he came to the conclusion that it isn't an entrenched right, but that they can't conclude it's an entrenched right. And he came to the conclusion, so I can't remember details of how he did that, and I didn't read it in great detail, because I'm not doing like a thorough parsing of this document. I'm not a lawyer anyway. But then they went on to the question of reliance and whether they rely on and then with reliance he made this point, which I already said in previous videos, so I won't go into it in any detail now, but that this is really a decision for the legislature rather than the judiciary. The judiciary make a very clear distinction as what the judiciary should do, and they're very careful not to go overstep into legislature, like making new laws kind of approach. And then they're sometimes criticised for going too far in that direction. And so he's saying, so that eventually is why they are considering throwing out Roe versus Wade, because they're saying that it might be going too far towards the legislature. Now, I just want to talk a little bit about this whole idea about judicial independence from politics. So Justice Roberts said, who's the kind of head judge and kind of centrist, that we don't have Obama judges or Trump judges or Bush judges or Clinton judges. What we have is an extraordinary group of dedicated judges doing their level best to equal rights to those appearing before them, so they don't make decisions before it comes. So, and Justin Collins gave several examples where they've ruled against United States versus Nixon, and there's it's a very clear case where they ruled against President Nixon. And so now people say, but then how can they overturn Roe versus Wade? Because if you read their statements, the confirmation clearings, if you're rather naive, kind of just like not very logically precise in your language, and then you look at their language, it may seem that they were saying that they're not going to overturn Roe versus Wade. And in my case, I didn't see them as actually saying that, but because I'm trained to be very logically precise. I did the logical foundations of mathematics, so I could see that they never said that Roe versus Wade was untouchable, but they did say that there was very strong reliance in Casey in the way it looks at Roe versus Wade. So it's natural to conclude from that they're not likely to throw out Roe versus Wade, because they said there's very strong reliance in Casey. What very few people, I didn't see anyone at the time saying it, was to say that perhaps they would come to the conclusion that the reliance in Casey was unfounded. And that's basically what they've done now, that the reliance in Casey was something that the legislature should look at rather than the judiciary. So that's what the draft did. And so they haven't said there's no reliance. They've said there's no reliance and even just a draft opinion, which other justices may have said is wrong. But in the draft opinion, he didn't say there's no reliance. He just said that there isn't a reliance of reform, that the judiciary are in the right position, are the right body of people to make a decision about. And so in the draft decision they said the legislature should make a decision about whether there's reliance, because it's of the particular kind of reliance that it is. So that's basically what they're saying. So the legislature should say, well, people do rely on a right to abortion, so we've got to legislate it into law. And if they do that, then they would support the legislature, because they are just interpreting. So they won't override that. They won't say there's anything wrong with that. That is correct. They've made very clear in this that if the legislature, in this draft opinion, that if the legislatures decide that there is a reliance on Roe versus Wade, and there is a right to abortion, then they were the right people to make that decision. So there's no way that if the legislature make that decision, there's no way the Supreme Court is going to change it back again. It can't. So only the legislature, if this draft opinion comes through, it's very, very clear that it's saying it's the legislature that has to make that decision, not us. The other side of that is that there's no way the Supreme Court could override if the legislature make that decision. So it's a very clear statement, this is for the legislature, you go over and do your decision because it's not for us. And that's basically his point of view. So he's not saying there's no reliance, he's saying that the reliance is a matter for the legislature. And that is what nobody really expected from what the justices said during their nominations. That's the big surprise. Nobody really expected them to say that reliance is a matter for the legislature. And that really is what's new with this new draft, if it goes through, which we don't know if it will. I keep repeating that because people keep saying that keep saying it's going to happen. I think we need to keep very clear that it's not decided yet. So now we look at what Kavanaugh said to Susan Collins. He said justice said to set aside all personal preferences. Well, I think it's pretty clear that Alito is not relying on personal preferences. He's relying on his legal interpretive point of view. There's no way of knowing what his personal preferences is from this draft. And so, I mean, he has aligned personal preferences, but as a justice, he wouldn't use that. And then 3 of the 4 cases he calls were ones where the court acts as a check on presidential power. And so the Supreme Court suggests a compelling interest in birth control, precedents around in the very Constitution itself. Then he hasn't got anything against that because he's not actually using precedents in this, because he's saying that there isn't a precedent for Casey. So he hasn't gone against that. So precedent can't be trimmed, narrowed, discarded or overlooked, but he can, to overturn precedent, the previous decision must be grievously wrong or deeply inconsistent with the law. So he's decided that the precedent of Roe versus Wade is a precedent, and Casey is using Roe versus Wade as a precedent. Now Casey and Roe versus Wade are both precedents, so to overturn it must be grievously wrong or deeply inconsistent with the law. So he hasn't. So if we go into that draft in more detail, he must be making those points too. I'm not sure where he says it's grievously wrong or deeply inconsistent, but he just says it's not depending on reliance. That's the only bit I focused on. He will be making those other points too somewhere. And decisions on precedents are essential for public confidence. And then he opposes litmus tests on personal view of politics because he fully expects them to decide on all personal views. And he's been unequivocal that the president, no president above, well, that's not related here. This is just going through. So, grievously wrong, deeply inconsistent with law. I suppose I should look up at this, but I mean, I'm not sure if it's really important because the whole thing is going to change anyway. But if any of you really need me to have a look at that, and I can just as a layperson, have a look at what he says on that, I could do that. And then this is about how the justices think about empirical studies of their ideologies. So this is about it's certainly true that justices do make. So when people make these researches, they do find that liberal and conservative justice predicts well many of their decisions. Not all of them. There are quite a lot that it doesn't predict. So they often make things that don't exactly fit. Indeed, it's quite a lot. It's only a slight bias in the direction that there's a certain percentage towards. It's not like they always do. And then if you look at this thing, then they find there's no way to look at the judge's actual state of mind, and instead they look at the way they behave, and then it appears to be motivated by preference of beliefs of an ideological character. But then if you look at how the judges think, they go on to they talk about a judge's ideology. An example would be Scalia's ideology of favouring the original meaning of the text as a means of interpretation. So So yes, they do have an ideology, but it's nothing to do with their personal, like Republican or Democrat or anything like that. So if you look at how the justices themselves explain what they're doing, and it may be likely to make decisions that Republican politicians favour, but that's not the reason. And this justice is a vocal critic of this body of work, and he says that they don't take legal doctrine very seriously. It's another problem in the Constitution, and it's disrespecting with the metaphysical nonsense of laws that have to be what's that? Dispensing and it's all that's kind of satire thing going on. That's it's quite complicated by the way politicians but the whole point here is that it's talking about the breaches in law between law and politics. The other kind of slightly sideways kind of language, if you're autistic, it can be quite hard to follow sometimes what they mean by the way they talk, because they talk in a kind of sideways way, quite often justices. But if legal and political decision making and the kind of side back to front kind of way of talking, but it talks here about the wall of separation between law and politics that legal scholars have laboured mightily for decades to elect and defend, and he's saying that the empirical world is breaching this wall, and he says that if this was to actually happen, if basically he's talking about if justices were to start treating their work in this kind of legal way, then and so it is in this kind of legislative way, and if political decision making was to be seen to be the same sort of thing as justices do, then it would be unclear why judges should pay any especially to legal instead of policy arguments. And why would they even listen to legal arguments if it's really based on policy? And it would then really not be a separate discipline from the Congress. Basically, it would be just another chamber of Congress that makes political decisions about legal laws. And he's saying that's not the direction that lawyers want to go. And they don't want to make the Supreme Court a kind of political way of deciding legal cases. So they and any breaches would threaten to diminish both the range of policy questions which legal scholars may attempt to claim special expertise and executive influence that they could have on those questions. So the lawyers themselves, they don't want to go in this direction of getting ideology, getting political ideology mixed up into their legal cases. They want to continue to keep a very big, clear separation, and so they're pushing back against this empirical work that seems to suggest that they're doing their legal things based on politics. They're saying we're not doing that because our ideology is not based on politics, and we don't want to do that, because if we do that, then what's the point in the justice? So that's basically that argument. And then if you look at the way justices are selected in the United Kingdom, then they're selected on merit by a commission of justices and lawyers. We don't use our Prime Minister. I mean, the Prime Minister does, in a token way, select the justice, but he's told who to select, and he's got no ability to change that selection. So we don't have Margaret Thatcher or George Brown or Boris Johnson judges in the United Kingdom. We just have judges. So we never have this ever come up as to who selected that judge. And so for that reason, there's no politics There's never, like when the judges made a decision against Boris Johnson in 2021, nobody for a moment thought that that was because they were Labour judges. Boris Johnson is Conservative. They just said, well, Boris Johnson, the very experienced our Supreme Court has decided that what he did is against the law. So therefore it's illegal, and that's just the end of it. And there isn't any of this long, complicated discussion of were the justices were they biased in any political way. There's not even the slightest shred of a thought that a justice ever could do that. It would be a very inexperienced, very young justice who has not learned how to do his job properly, and really professional, very, very bad professional conduct, professional misconduct really, to do that. So that's how we think about it in the United Kingdom, and it looks like it's pretty clear that that's also how justices in the United States think about what they're doing. So it's only politicians and researchers who are not themselves kind of very much into the judiciary side of things. They're the only ones who say that in the United States. So I think if hypothetically USA was to use a commission of lawyers and justices to select the Supreme Court, then this whole question would go away, because the justices wouldn't be selected by presidents, so there'd be no way to identify them as being connected with any political party. Because if you look at the ones that are pro-life, the only thing that connects them with a political party is that they were selected by President Trump. If you look at the LGBT decisions, there's nothing Republican about that. Or if you look at their other decisions, they often make decisions against Trump. It's only on this particular question of abortion, and that's only because Trump, given all the experienced justices in the United States, he chose ones that had made decisions in that particular direction. So I think there's absolutely no basis at all in this idea that justices in the United States are guilty of professional misconduct, which is what it would be if they were using politics to decide their cases. If they were doing that, it would be very serious, very, very bad conduct for a justice to make a decision on the basis of political ideas or personal ideology or which party they belong to or anything like that. And I mean, if it was and again, even at lower courts as well. So Trump has gone around and he's selected lots of pro-choice justices in lower courts, but they are not themselves Trump justices. They're just justices who have legal ideology similarly, who make pro-choice decisions for legal reasons, not for political reasons. So I don't think there's any reason to suppose that any of the professional, well-trained justices, of course you always have a few bad apples. There may be justices somewhere in the United States, just like you have professional misconduct of doctors. There may be some professional misconduct of some of the justices in the United States, but your typical justice is not going to be making decisions based on politics or personal ideology. And it would be scandalous if a justice at the high level of the Supreme Court was to do something like that. So I think we have a different. I know that it's a very different system in the United Kingdom, but I think this perspective may help you to understand, coming from a country where there isn't anything like that, to try to understand what is going on in the United States. So the ideological bias, there is an ideological bias in the Supreme Court, but it's not coming from the justices. It's coming from the presidents who selected those justices. Every reason to believe that the justices themselves are being professional in their decision as very experienced justices who have striven mightily for their entire professional life to separate personal preferences from legal decisions. So with that background, then hopefully that helps some of you to be less scared about this idea that somehow they've got a Republican agenda. They don't. They happen. It's not a surprise that they have a tendency pro-choice just because they were selected by presidents who have that agenda. But it's the politicians have that agenda, and there's no correlation between what a justice decides on choice and what decides on, say, gay marriage, because they're very different legal topics. So there's no reason to expect what they decide on one to inform what they decide on the other, and the evidence so far is that this going around, and if they were to select, well, in theory Trump could have said, well, I want to try and find a justice who both makes a choice I like on abortion and makes a choice I like on gay marriage. I don't even know what Trump's view is on gay marriage, but he could have done that. That would limit the number of justices that he could select significantly, because there will only be a few who make really quite extreme in the legal spectrum views about choice, and then very unlikely that any of those make similarly kind of towards the extreme, towards one end of the spectrum view about a completely different legal topic. So the more topics you would add in, the smaller and smaller pool of justices you can choose from, and so you want to choose a very high quality justice to have a chance of getting through the Senate. And so it's pretty much as you can achieve is to do that for just one topic. And so they focused on just one topic, on pro-choice, and there's nothing in them being pro-choice to really predict anything about any other of the topics that they might discuss, unless it's very, very closely related, like in some other case, in some other kind of a case that involves cutting short an unborn human being. Then it's clear they have certain legal decisions on that particular topic. So if there were other cases, maybe something to do with surgery or something that involved that, then they might make a similar decision. It would have to be legally similar, so I'm not confident to decide what would be legally similar. But it would have to be legally very similar to a case on abortion for this to be relevant. And so hopefully this helps you to be less scared that they're going to do anything about. There's no reason to expect any change on gay marriage or contraception or any other topic, unless it is really very closely legally connected. And they don't see, even to contraception, it's in that list. So if you have the morning after contraception, then that is preventing an unborn human life in a way, even though it hasn't yet implanted in the fallopian tubes. It's still there could be some reasoning, but it's a very weak kind of reasoning that is a form of life, because it mightn't even come to anything. And so it seems that Alito is pretty clear that their conclusion would not undermine any future decisions even about contraception, and this also would therefore suggest that it's unlikely to have any effect, that the choice, that the pro-life decision selection by president is probably not likely to have any effect, if anything to do with contraception comes their way either. It's probably likely to be a similar thing to gay marriage and everything else, because Alito says that it's not, doesn't undermine that, and so it's very unlikely really that it has much legal connection according to the way they look at things. So I don't think, obviously they could overturn something else, but it would be as unlikely as it was before, then they could have before Trump made these choices about the new justices. And the change of justices makes no difference, as far as I can tell, on what they might, based on sources I looked at and things, on what decisions they might make on these other topics like gay marriage or contraception. So I don't see, and the people, they just use very weak, not legal arguments, basically emotional arguments, saying that some very horrible person he's quoted from the 17th century, so therefore he's probably going to do something horrible like overturn gay marriage. I mean, it's not really a legal argument at all. It's not a logical argument. So I didn't see anything that really sensible in my brief read of what people are saying in the papers that really suggests that there would be any connection between this conclusion and anything to do with right to grey marriage or right contraception or any of these other